Okay, good morning everyone on this slightly damp Wednesday morning. Hopefully the weather's better with you all than it is with us. This morning we're joined by Managing Partner Ryland Ash, who's going to be talking to us about But Surely I Can't Be Held Responsible, which is design, negligence and your duty to warn. As always, if you could pop your questions into the Q&A panel facility in the toolbar at the bottom, and then at the end, Ryland will address as many of those as possible for you. So without any further ado, Ryland, over to you.
Good morning, everybody, and thank you very much for the introduction, Julie. So I intend to cover the issues of design negligence, duty to warn today. And the question is, surely I can't be held responsible. And the reason why the seminar is called this is because in a surprising number of cases, parties will not be fully aware of the obligations that they have in relation to design. There are risks that are associated with decision making. It's been said by an illustrious judge many years ago in England that to decide is to design. So design itself is not a straightforward concept. It's not something that is necessarily obvious by virtue of the fact you are an architect or called a designer or a consultant who's asked to design something, or even a contractor who's asked to design something and agrees to do so in their contract. It may be that by making decisions about certain aspects of the work that in fact you are designing. So that's why you have to be careful, and that's why the seminar has the title that it has. So if we look at the slides, I'll take you through a number of examples of each area identified in the title. But we'll start with, first of all, with design liability itself. So once you've established what design is, the next question is who's responsible for it? Because it can be that you can limit your responsibility or your liability in respect of the design that you are undertaking. But the first thing to look at is the legal test, is the test in law about what liability you've got and what standard that you're going to be held to. And that's a big part of this subject, because there are differing standards in relation to design. Design is a subjective, in many ways, subject, in the sense that, you know, design could come in many shapes and forms. The test of whether a design meets requirements is never straightforward. It can be, in some circumstances, a straightforward issue if, for example, you've got calculations that are simply wrong, for example. But sometimes it can be more about the aesthetic side of a design, or about its purpose and whether it achieves that purpose. And then the question is, well, so what? Was there an obligation to meet that purpose from the outset? Now, English law treats design and build together as a product. So there are aspects of the law which relate to products which are relevant to design. If you're just building something and you're not designing it, then in many ways you escape that liability and you don't carry that risk of there being a breach in relation to the product itself or achieving a purpose. Ultimately, if someone gives you a design and says, there you go, please build that, and it turns out that that design was inadequate, well, then it's probably somebody else's problem. But in some cases, contractors will take on that liability for design or for achieving a purpose, as we'll see. So what does the law say? Well, this goes back to a pretty horrific hospital case, in fact, which is from 1957 where Bolam sued Friern Hospital Management Committee. And in this case, it was to do with psychological treatment of a patient. And back then in the 50s, they believed that electroconvulsive shock treatment, actual physical shocking of a person, would treat certain conditions. Of course, that all turned out to be nonsense, but at the time they believed it. And as is the problem with many things in medicine over time, and science can reveal that in fact they weren't such a good idea. But what happened was that the patient sustained injuries during the treatment, and the question was whether or not the hospital was liable for those injuries, because they made the decision to give this treatment. And so in considering whether or not there was a liability, which in this case they decided there wasn't, but what was more important was that this case set down the test for whether or not an expert is negligent, effectively, the standard to which they will be held accountable. And this translates to designers, as we'll see later. But in this case, what the court said was that where some special skill is exercised, the test for negligence is not the test of the man on the Clapham omnibus, which was a phrase that used to be thrown around in courts to explain how your average person might view something. But that's not the test, because he has not got this special skill. The test is the standard of the ordinary skilled man or person exercising or professing to have that special skill. And actually, this case arguably created the whole expert witness sector, because from beyond this point, whenever there was a question about whether or not an expert or a specialist had been negligent, had failed in their duties, they were to be held to this standard, which is effectively the standard of their peers and other experts in that particular area. And then they were to give opinions about whether or not they felt that what had been done by the person in the firing line was either in accordance with those standards or fell below those standards. And if it fell below, if the service that had been provided fell below that standard, then they would be held negligent and accountable. The get out of jail for an expert or a specialist in that sense under this test is that if you can find one other person who is skilled in that area, who's convincing enough to say, well, I would have done the same thing, which is what happened in the Bolam case, then that specialist won't be held accountable. So that's the starting point in terms of design liability for negligence. Note that that's about negligence, and negligence is an area of law in its own right, which falls under the umbrella of the law of tort, which is to do with duties of care and whether you fall below that and whether you are negligent. And negligence exists separate from and in addition to any contractual obligations. So actually they can coexist. You can have contractual obligations and at the same time you can have tortious liabilities, and you can be negligent and in breach of contract. And it's for the victim, if you like, of that alleged breach to decide whether they're going to bring a claim under contract, if there is one, of course, or in tort. The other thing about negligence is that it can arise without a contract. So if you go to your GP and they prescribe the wrong medication to you, which has happened to me in the past, where I've actually been given a prescription for antidepressants instead of antibiotics. I make the point that they didn't think I needed the antidepressants, but once I'd taken them, not realizing, of course, because I trusted my doctor, unfortunately for me, and the pharmacist hadn't mentioned anything, I felt very happy, but still very unwell. And I realized that I'd been given the wrong medication. The doctor had been negligent. There wasn't any damage at the time. And I won't tell you the long story about how I sued the doctor and they're no longer there anymore. But I'm just joking. But the reality is that if a professional gives you advice, they could have a liability, even though there's no contract. So design liability can arise in other ways. If you look at the slides, you'll see that you can create a duty of care, which I've explained, without a contract. You could have a contract which sets down your design liability, a letter of appointment to do some design, or you may even say, I am going to verify or warrant that this design works, and it could be a design from somebody else. Where, like in the case, for example, where a contractor, design and build contractor, takes a design from an architect and says, I will now verify this design, I'll take responsibility for it, and I will build whatever has been designed. So that can be a contractual way of obviously taking on design liability. So you've got the duty of care, you've got the contract, and then you've got a duty to warn. Now, there's no set English common law duty to warn, but in the context of certain cases that have come before the courts have confirmed that there is, in certain circumstances, an expectation that a specialist, normally consultants or engineers, are the ones that tend to come before the courts. There is a duty on them to warn a client or indeed any third party that might be affected if there is an immediate danger or problem that they identify. And if you don't notify, then you could be held responsible for the consequences. So, for example, let's say a building was built, but the structure was unsafe, and you had a checking consultant on site. It should have been reasonably apparent to them that there were unsafe aspects to a building, and a failure to warn the client of those things at the time may well be a breach of that duty to warn. It's more difficult to pin that liability on a third party, such as a consultant, for example, unless they've got a very specific obligation to check structural adequacies. It's more often the case that what we're really talking about in a duty to warn is in fact on the designer themselves. If they're preparing designs and developing designs, in doing that, they should be identifying any obvious, dangerous or problematic aspects. And a client is entitled to expect that that person will notify them of those things and obviously give them an opportunity to deal with them and rectify them. So that's the duty to warn. And then you've got common law aspects of design liability. So that's the law. That's where case law, as I mentioned, in certain cases, the law will say there is a liability here by virtue of the fact that you have developed a piece of design. An example of that is the Henry Boot case comes to mind, which is not in your notes. But in that case, what happened was they were engaged, Henry Boot, to undertake construction works, and a very small part of the design, a design portion. But it transpired later that the design portion, although in isolation was okay, it didn't integrate properly with the overall design. And because of that, there was a problem. And the courts held that Henry Boot not only had an obligation in relation to their small portion of design, but they had to check the overall design to ensure that it complied or was adequate enough to allow this portion of design to be developed, which is a broader obligation. Subsequent to that, all the JCT contracts with design elements were changed. And you probably know today about the JCT form of contract saying that a contractor will not be liable for inadequacies in the employer's requirements. And that wording is in there because of that case. So prior to that, it was clearly the case that a contractor was taking on responsibility for certain inadequacies, and they had a duty to check for those inadequacies. And the reality is that where there are amendments made to the JCT contract, which there often are, that's one of the first things to change. Parties will remove that wording from the JCT saying that the contractor is not liable for inadequacies. So they have no risk in relation to the design that's been given to them, basically. Excuse me. If you remove that wording, then you revert back to the common law position, which is that the contractor does have to check the adequacy of those designs, certainly to the extent that their own design will integrate with that overall design. So it's important to note that if you are designing and building. In terms of design liability and contract, the starting point is always the same, which is that you will check the terms of the contract, and the contract should tell you to what extent you have a liability, if any, for design. And the best contracts are clear on these points, such as the JCT contracts, for example. If it's a design and build contract, then clearly the intention is that the contractor will be liable for the design. But that design may have been given to the contractor by a third party. So the question is, would they in that situation be liable for inadequacies in the requirements? Well, again, that depends on the wording that survives to the final version of the contract. But generally speaking, in terms of design liability and contract, the traditional approach to building has been that the employer would engage their own architect or designer who would design the scheme, and the contractor would just be responsible for building that scheme. They wouldn't be liable for the design at all. But it's becoming increasingly common that contractors do take on design. And certainly in the years that I've seen construction change, it's become a bigger market for design and build. And it's also a riskier market for contractors to take on design, because it's often unclear if they take on design responsibility, to what extent they have to verify, develop, and complete those designs, and what the liability is. And what's also a very common problem with them is the valuation of changes to that design. That tends to be a big area of controversy, and so it leads to disputes relating to changes and liability. But the traditional approach is to separate the two, and to obviously have a designer who's responsible and a contractor that's not. The next thing to consider is the exceptions or limitations to the liability for design under contracts. And as I said, different contracts will deal with this in different ways. And there may well be limitations to that design liability, depending on the wording of the contract. The first one to note is that discrepancies can sometimes create a limit to the design liability. So in most forms of contract, you'll have provisions, certainly in the JCT contract, which say that the contractor is under an obligation to notify the architect or the contract administrator of any discrepancy or divergence between the documents, being the drawings, the bills, instructions that are given, and or statutory requirements. And then the contract itself will determine whether or not that is a liability of the contractor, so that the contractor has to resolve the problem at their own cost. And invariably that's in a situation where the problem or discrepancy has been created by their own contractor's proposals, or if there has been a discrepancy between the documents that they have not prepared, the contractor's not prepared, for example, within the employer's requirements, if that needs to be resolved by way of an instruction or a change, then that will be valued as a change, and the contractor will be able to claim for any extra work. So that's discrepancies in the context of the contract. The next way that design liability can be limited under a contract is that there can be a contractor's design portion, or a CDP as it's known. And the JCT contracts, the standard building contract, intermediate, and minor works, they all have versions of that form which have contractor's design, which is to say a portion of the design becomes the liability of the contractor. An obvious example of this is where you have a scheme that's been designed by an architect, and then you engage a contractor who is responsible for completing the design in relation to the M&E. So the mechanical and engineering has not been completed in terms of design, and so that portion, as it's known, of the design is to then be developed by the contractor, but everything else has already been developed and completed, and so the contractor is not responsible for that overall design. But remember the Henry Boot case, you need to make sure that the contract says so, that the contract says that the contractor will not be responsible for any inadequacies. Otherwise, you fall back to the common law position, which is they've got to check everything. The third way that design liability can be changed under a contract is really more about a concurrent obligation in common law and the duty to warn. So I mentioned earlier that there's this duty to warn if there is anything dangerous or problematic, and that's for the designer, even when you're doing a portion of the design, or even when you are not effectively responsible for the design itself, but have certain skills or are an engineer or a consultant. You may be in the firing line if you are or ought to have been aware of danger or problems. And if somebody with your skills can say, actually, I should have identified this problem, then there may be a duty of care and there may be a risk of liability. An example here is the lack of buildability. So English law is quite unforgiving of contractors and designers, in the sense that it says that an employer because they are not considered to be skilled, although they may well be, in fully appreciating whether or not something can be built. There are some good cases on this in relation to buildings where an employer says, I want this built, and this is the drawing of it, and this is what I want you to do. But actually it's impossible. It can't be built, certainly not in the way envisaged. And the law says, well, that's not really the employer's problem. That's the contractor's problem. The contractor has a duty to warn the employer that it can't be built, or certainly can't be built in the way that they want it to be. So that duty to warn extends to whether or not something can actually even be built. It's important to notify a client as soon as you consider that there could be any challenges in relation to what they've asked for. And as unfair as it may seem, even if it was impossible, if it's not built and you haven't warned a client, ultimately a contractor would still be in breach of contract. You'd be in breach of contract for failing to build something that was impossible, because it was your duty to say it was impossible from the earliest opportunity. And therein lies the reason for the duty to warn. So the next issue to cover is, what standard must a designer meet? And there are effectively two standards: reasonable care and skill, and fitness for purpose, which is the higher standard. But there are a range of different standards, practically speaking, between the two, where you can have reasonable care and skill plus, for example, adding the words diligence. Reasonable care, skill, and diligence adds a little bit extra. But ultimately, you start really with the requirements of the contract, if there is one, and hopefully there is. If there's a contract, you're looking at what the obligations will be. And I'll expand on that in a moment when we come to another case which is relevant to that, which is the hook guard case. But we'll start with the Stormont Main Working Men's Club case of 1988. So the issue in this case was about snooker rooms and snooker tables. And there was a design put in place to build certain rooms, which it turned out later were for the purpose of containing a certain amount of snooker tables to allow professional players to play. And once it had been built and the snooker tables were installed, which is a bit too late, to be honest, but anyway, they didn't find out until that time that there wasn't enough room around the snooker tables to actually be able to play. The players couldn't get their arms out. For those of you who've been in a pub that's too small, or tried to play snooker or pool at home, you'll know that you have to lean up against the wall or hold the stick in the air, which is no good for the cue, of course, not stick. The professional players weren't very pleased about this, and neither was the owner. So a claim was made against the designer, but the claim failed. The court said, yes, this is all terrible, but it was not in the brief for the designer that was the purpose of the building, and therefore there's no breach of contract. The courts did go on to say that if the purpose had been clearly identified, then it would have been a different story. But ultimately, in this case, the designer got away with it. And so I suspect they probably changed it to a pool hall, or had several less snooker tables in their building, in the old men's club. But what the courts decided then, really, in essence, was that you use reasonable care and skill. The ordinary competent practitioner is the standard, but it's the clarification of the design brief, which is really important. That will limit, in many ways, the obligations that you have. So a quote from the case is that if the client has expressed his instructions in terms which leave the architect in doubt as to what the purpose is, it might be a snooker hall, it might be a swimming pool or a gym, I don't know. The architect has a duty to ascertain which is the purpose he is instructed to achieve. So the architect does have to consider it if there are a number of purposes. In making his decision, an architect has a duty to exercise due care to ensure that the design should be reasonably effective to achieve the client's purpose. So it's a question of discretion if the purpose is made clear, but if it's not, then the architect will invariably not be liable for a failure to achieve that purpose, because there is no automatic fitness for purpose obligation. The standard is really of reasonable care and skill of a competent practitioner. So, in terms of design liability, there are three principles that have to be understood. The first one is that you have to look at the express terms of the contract or design brief. What does it say that you're taking responsibility for? And are there any limits on that liability? And are there any exclusions? The next thing to consider is implied contractual terms. They are terms that come about from the law, but are not stated in the contract. So they will include the CDM regulations, for example. They'll say that you have to ensure that health and safety is maintained and that the works are safe and adequate from that perspective. So that's an implied duty, implied obligation, which is not necessarily in your contract. But as a principal designer, you have to make sure those requirements are satisfied. Another example are from statutory requirements from the Supply of Goods and Services Act. The Supply of Goods and Services Act says in section 13 that a person providing a service, such as a designer or a builder or any other person in the course of business, will use reasonable care and skill. So that's your basic standard, if you like, that's implied by statute in law. That's an implied term in your contract. The same act also says in section 14 that you'll complete those works within a reasonable time. So timing of satisfaction of your obligations also becomes relevant in terms of your liability. You could be liable for completing it late or slow by way of an implied obligation. And the other thing to mention in terms of implied obligations is that any materials that are supplied are required to be under the Sale of Goods Act, Supply of Goods and Services, reasonably fit for purpose. And you'll often see in contracts as well that materials can't be dangerous or deleterious. So you have to make sure that the materials that are specified are suitable, reasonably suitable, or fit for their purpose. So fit for purpose in relation to materials is a requirement, but fit for purpose in relation to the design itself is a separate concept. So that's implied terms. And then finally, you've got to be aware of the tort of negligence. As I say, the tort of negligence will sit underneath or above, together with the contractual obligations. So your duty of care, and then whether or not you have acted or failed to act in accordance with the professional standards that you should be held to. That will be a consideration in relation to negligence. So they're the three things that you need to be aware of where you're looking at design liability. So how does design liability come about? Sometimes it's obvious, sometimes it's not so obvious. But there are a few things to mention. First of all, the concept of design liability can not only cover design, physical designs or drawings that turn out to be wrong, or calculations, which is the more obvious kind, but it can also cover negligent advice. So where you advise a client and it turns out to be wrong, you can have a liability in relation to design. The next thing to consider is economic loss. So the simple point is that the starting point really in English law is that you are not able to recover pure economic loss in relation to negligence. So if there's a claim made against you for design liability in negligence, and the losses that are being sought are purely money related, then there is a big hurdle to overcome to make that claim. And the starting point is really that it should not succeed. So that's a very important point to remember when considering making such a claim. What will be covered is non-economic losses. So, for example, physical damage. If a design is negligent and there's a collapse of a part of a building or a whole building, and then damage to other products or materials inside, anything to do with damage, physical damage, would be recoverable. But if you then try and recover loss of profit or overhead or delay related costs or any other costs that are purely economic, such as finance or banking charges or whatever it might be, then unfortunately you're unlikely to be able to recover them. So pure economic loss claims are likely to fail in relation to negligence. And then you've got the common law standards, which is reasonable care and skill under the Bolam test, which I explained earlier. The other thing to consider is net contribution clauses. So in contract, if you have a liability, you have a right to bring a claim for 100% of your losses against the party you think is responsible. And you can seek to recover all of those losses from any one of the parties that may be responsible for the losses. You'd have to prove that they've suffered, that you've suffered the loss and that they caused the loss. But ultimately, you can seek to recover all of those losses from any given party. Often what you would do is you would go after the one with the most money, because there's no point in going after somebody who can't pay you back, or perhaps a party that's insured, more importantly, who can afford and has the cover to be able to reimburse you for your losses. In negligence, there are there is the concept of contributory negligence. So that is where you can split the liabilities between the parties. You can say that the designer was 10% responsible, the builder was 50%, the engineers were 40%, or whoever and however you wish or think that it should be appropriately split. And that's in negligence. But in contract, you can also have an equivalent provision, which is called a net contribution clause, which allows you to apportion liability between different parties. And you'll often see these provisions in contracts, but you may not. They may not be there. And if they're not, then the 100% liability kicks in. And you'll often see net contribution clauses in the appointment of architects and engineers. An example of this is a case, West versus Ian Finley Associates, went to the Court of Appeal. The architect in this case was liable for a failure to inspect the M&E fittings. But the Court of Appeal held that the architect was entitled to rely upon a net contribution clause in the conditions of their engagement, which limited the liability relative to the contractors. So the contractor was only responsible for part, and so was the architect. So it split down and reduced the liability of the architect. If there had not been that provision, then the architect would have been 100% liable. Now, in terms of negligent advice, the key case is going back to 1964, Headley, Byron and Heller. And that was to do with financial advice. And the case developed the concept that if advice was given that transpired to be wrong, in this case it was about investments, saying, yeah, these are fantastic investments, when really they weren't, then what can happen is you can create, even though you don't have a contract with the person giving the advice, that can create a special relationship, not like the one between America and the UK, but more of a legal special relationship, a proximity and a closeness, and a reliance where you trusted this person as an expert to give you good advice, and they let you down. And the court said you should, in those cases, in those situations, you should be able to make a claim. So that established this concept of negligent advice. And then over the years, of course, that's extended to solicitors giving advice, engineers, consultants, and obviously the financial services as well. So, I mean, this is a good law to protect people and parties from negligent advice. And ultimately, there can be a liability there for giving advice in relation to a design. At the beginning of this seminar, I said that sometimes parties don't recognise that they've taken on a liability. And this is one of those, oh, wow, I can't believe I've taken on liability concepts, because you think, well, there's nothing in my contract saying I'm doing design, and yet I've given some advice. I've recommended where to put some plumbing in the wall, or I've recommended where to put a boiler, or what rating boiler to install, or a design solution of some sort, because I'm just one of those helpful kind of guys. And ultimately, it comes back to bite you. So you've got to be very careful not to do too much and go beyond your retainer or contract. And negligent advice is one of those areas where a party has to be very careful. What you can do, of course, is caveat it and say I won't be responsible, and that's a common way around it. But you'll be surprised the number of cases that where parties don't do that. It's quite rare that they do caveat at all. So negligent advice can be a problem, and it can create liability. So in a situation where a consultant gives advice to a party and it's clear that the advice may be acted upon, the advice is given negligently, the party acts upon the advice and as a result suffers a loss, consultant may be liable for the losses, even though there's no contract between them and the losses are pure economic loss. So this is the point. I mentioned the limitation in negligence that you cannot, the starting point is that you cannot claim pure economic loss. But if you've created a special relationship, such as this, as created by Head v. Byron, then you might suddenly become liable for economic loss, which is a big concern, of course. So you need to be very careful about the advice that you give, the context that you give it in, and also make sure you caveat and limit as best you can your liability. So the pure economic loss principle in the case of Henderson, Merritt and Syndicates 94 was extending this principle of the Head v. Byron case of the special relationship to negligent acts. So the courts were clearly comfortable that it shouldn't just be about financial advice, that a liability can be created in design or negligent advice, including design. Comments on the three-stage test were that if there's a proximity between the parties, a reliance on the advice, they've relied upon the advice, it was reasonable to rely upon the advice, and the advice was wrong, then there's no question of fairness. It is what it is. In the context of a professional retainer, proximity and reliance could be presumed. So if there's an appointment document, then effectively proximity and reliance is already there. So advice given under that retainer or appointment in relation to design, which turns out to be negligent, could well lead to a special relationship whereby you become liable for damages and potentially pure economic loss as well. So as I said, you start with the principle that you can't recover economic loss, but there are situations where pure economic loss can be recovered. And remember the distinction between contract and negligence. In contract, you can recover pure economic loss. It's not a problem. But in negligence, it's more difficult. The only way you can do it is if you can establish this special relationship, the proximity and the reliance. In terms of an example of where an architect can be liable to a contractor, there's another useful case here to read, which is Cliff Holdings and Parkman 97. So following the previous case, Henderson and Merritt, the proper test to be applied was whether the architect has assumed a responsibility for giving advice to a contractor in circumstances where he knew it was likely to be relied upon, that's the reliance point, and where it was reasonably foreseeable that if it is relied upon, and if it was carelessly given, economic damage could or would or might arise and result to the contractor. And the court said, I have no difficulty in concluding that the architect owed a duty of care in tort to the contractor concurrent with the contractual duty of care of the engineer. Position of the professional differs from that of the ordinary trade subcontractor. So a professional is in a situation where they can be exposed to economic losses if their advice is wrong. The way around that is to ensure that you limit your liability within your appointment or contract, but you still may have a liability in tort. And that's why it's important to caveat any advice, record it in writing, and make sure you protect yourself when giving that advice. On the other hand, professionals are very different to subcontractors, the ordinary subcontractor or extraordinary subcontractor or contractor. If you're just undertaking work and you don't have design liability, then clearly you're not going to be held to those same higher standards. You're going to be held to the standard of reasonable care and skill, either stated in the contract or implied from implied terms or the common law. So the standard to be achieved from a professional is obviously up here, and the reasonable care and skill of a builder or a subcontractor or contractor, it starts at the bottom there with reasonable care and skill. What about engineers? Are they liable to the contractor? Good case here, Galliford Try and Mott MacDonald in 2008. So the drawings had stated that this document had not been relied upon or used in circumstances other than those for which it was originally prepared and for which Mott MacDonald was commissioned. Mott MacDonald accepts no responsibility for this document to any party other than the persons by whom it was commissioned. Now, in this case, the court said, well, disclaimer like that is only one factor. You need to look at the terms of the appointment. The terms of the appointment say, well, you are responsible for all drawings, then clearly it would be a different case and there may well have been a liability. But in this case, they said it was just one factor, but ultimately it was enough. It was enough to get them off the hook. What they said was it's an important factor in determining whether a duty of care arises. One cannot usually voluntarily undertake a responsibility when one tells all concerned that one is not accepting such responsibility. So as long as you tell everyone, I'm not having responsibility for this, and put it on your drawings, put it in your documents, and put it on your emails, then it will be clear that you're not accepting responsibility. So in that case, it was held that they didn't have liability. Now, in terms of the standard that's required of a designer, I've mentioned that you've got reasonable care and skill and not fitness for purpose. Now, reasonable care and skill will apply where you are just building to a design produced by somebody else. Okay, so you produce whatever, you build whatever has been designed, and if the design turns out to be wrong, the inadequacy in the design is somebody else's problem, and you should be paid to put it right, in theory, for changes and variations that are necessary. When it comes to products, producing a product, as I mentioned, there are implied obligations and standards which come in from statute, which say that a product has to be reasonably fit for purpose. It also has to be of satisfactory quality in terms of materials. So products and workmanship are different concepts. Now, what happens when you design and build is that actually the workmanship comes over here and it sits together. So the courts look at it and say, well, you've got to design something that is reasonably fit for purpose, and you've got a workmanship obligation here. Now, what you can do in your contract is you can lower that standard down to reasonable care and skill, so that the design is one where you simply use reasonable care and skill. But if you don't put those words in, then the likelihood is that the standard, the default standard in English law is actually the higher one. So you've still got to achieve the purpose for which the building or construction project was intended. That's the default position, unless you lower the standard in your contracts. And that's what the JCT standard building contracts do. In the NEC contracts, you have option X15, which says that the standard of design, if there is a design obligation, is reasonable care and skill. So that again brings the standard down lower. but you start up here. You start with reasonable fitness for purpose, rather than reasonable care and skill. So watch out for that. So it's not just the design and build contractors who are particularly exposed because of their implied position, but also for professionals who may be asked to sign terms which are either explicitly or impliedly impose fitness for purpose obligations. Such clauses will need detailed consideration, as they could have the effect of placing obligations outside of your insured risk and therefore putting the consultant or contractor at greater risk. It's sometimes helpful to have a clause explicitly denying any fitness for purpose obligation. So the point here is that if your contracts do include fitness for purpose, be very careful. Ideally, you don't want to have any obligations that are fitness for purpose because, as I've identified there, it's very difficult, if not impossible, to get insurance to cover a fitness for purpose obligation, because an insurer will say, well, it's too subjective and it's too high a standard. So that's a risk that really no project should take on, where you're effectively asking someone to build something without insurance. Not a good idea. So the default position is fitness for purpose. So you must have provisions in your contract that if you're going to do fitness for purpose, first of all, that the purpose is clear, that there is insurance if you can get it. Otherwise, you want to stick to that reasonable care and skill standard. And the only way you can do that is by adding words into the contract that say it's reasonable care and skill and that it's not fitness for purpose. Now, in terms of the case law on this, the leading case is a Supreme Court case from 2017 on this slide here, MT Hookgart and Eon Climate and Renewables. And in this case, there were piles designed for an offshore wind farm. And the piles failed in the water. And the question was, who was responsible for the rebuild costs, which were millions of pounds? And the contractor argued that they'd used reasonable care and skill. And that's what the contract said it had to do. The contract actually said use reasonable care and skill. And the contract said that there is an international standard with a code that you have to achieve, H something or other. And they had achieved that standard. It turned out that that standard was baloney, that the standard wasn't good enough. And in fact, even though they built to the standard, the piles still failed. Unfortunately for the contractor, buried within the specification was also a requirement that the piles should have a design life of 20 years. And clearly they only lasted 5 minutes. So the problem was that there was a discrepancy between the 10-year design life and this international standard. And the Court of Appeal said, well, you've used reasonable care and skill and you've met the standard of the international requirements, and therefore you're not liable. The Supreme Court reversed that and said, no, there's two standards here, and actually the obligation is to meet the higher one. It doesn't matter that it was buried in the specification. There's no such thing as buried in the specification. Specification is the specification. So it's a real warning to contractors who've got design liability that you have to check very carefully all requirements in your contract. And even if you say reasonable care and skill, there may be something in there which raises that standard. So in this case, the contractor was liable for a defective design and had to pay for the reinstatement. In terms of negligence, how do you prove it? You have to show the duty of care and then you have to show a breach, that you fell below that standard of a professional person or skilled person in that area, remember, not the person on the Clapham omnibus or the man in the pub. In terms of how long you're liable for, that will depend on, first of all, how your contract was created. So if you have a contract that's signed underhand, not a deed, just signed, or perhaps a contract created verbally or by conduct that's never been signed, then ultimately there will be a 6-year liability period from breach. If there's a deed, then it will be 12 years, 12 years from the breach that you have to bring that claim. In tort, so in negligence, it's 6 years that you have to bring the claim within from the damage, or when it ought to have reasonably have been apparent that the damage occurred. And that's often not so clear, because you have to say, well, acting reasonably, for example, if you were supposed to be maintaining a building, if you had been maintaining it, then you could argue that it should have been discovered earlier. So there are lots of arguments around discovery, but ultimately it's 6 years from the damage. Or it could be 3 years, if longer, from when any person in whom the cause of action was vested that had first knowledge. Okay, so when you had first knowledge of the damage, you have to bring your claim within 3 years, and that can allow an extension to the 6 years, so long as you bring that claim within 3 years, up to 12 years after the works have been complete. And then up to 15 years in total, that's the long stop for an act of negligence. So 15 years is the absolute maximum. So in terms of implied contract terms, I've mentioned what they are. They are the ones you have to look out for are reasonable care and skill, complete within a reasonable time, and providing materials that are satisfactory quality and reasonably fit for purpose. They're the main ones that you really have to consider, because they're not written into the contract, whatever form of contract you've got. In terms of design liability under different forms of contract, obviously there are a number of provisions that are relevant to this, but strictly speaking, under the JCT, in the standard forms, you've got the standard of a professional designer, which is effectively reasonable care and skill. Under the NEC, you have to use option X15 to get to that standard. Otherwise, if you haven't got option X15, the default position is that higher fitness for purpose obligation. So watch out for the NEC contract, particularly in relation to design. What practical steps can a subcontractor take to reduce the risk of liability, or a contractor? Well, the key thing is to review the contract very carefully and or the appointment. Fight back on the provisions that say that you become liable for any inadequacies in any design by others. The reality is, if someone else has produced a design and someone is saying to you, I want you to be responsible for everything, you'd say, well, why? You've paid someone else to do this. They've got insurance. If there's something wrong with it, you go back to them. I don't want this risk. It's unnecessary. So fight back on those provisions, limit your exposure. And the other important point I've mentioned is about these caveats, the disclaimers. Think about the example of the disclaimer on the drawings. That's a key thing to remember to put into your documents to limit your liability. In terms of a collateral warranty, well, all that will do is it will create a contractual link between you and a third party. So rather than simply having a duty of care in tort without a contract, what it does, it creates a contract, which means the concept of economic loss is not something you have to worry about in terms of making a claim. That will be a given. So that's the real distinction, is whether or not you're simply going to rely upon negligence, or if there's a collateral warranty between you as the designer and as a client or a beneficiary, then ultimately you can make a claim under the collateral warranty itself. The other thing to remember is that there are step-in rights in relation to if there is an insolvency act, there could still be a claim from that party or the beneficiary. So all of this is in relation to the need for a contractual link between the parties. And the key case on the rule of privity, which is the fact that you need a contractual link before you can make a claim, is set out in the Dunlop Pneumatic Tyre Company case there, which is mentioned in the slides. So only a party to a contract can sue under it. But the reality is you can still make claims in negligence, as I've outlined, even without a contract. But remember the limitations in relation to economic loss and that special relationship. The last thing to mention is that you can have third-party rights created under the Contracts Rights of Third Parties Act. That's instead of the collateral warranties. So it may be that in your contract, it would say that the tenants or funders of a project can have rights under your contract, which could mean that you could face claims from those parties in relation to the design that you've developed or advice that you've given, which may turn out to be wrong. So it's worth mentioning in terms of where claims may come from, those rights can be created by the Third Party Rights Act. I've covered step-in rights, which is the separate rights to those of the beneficiary, which is ultimately where, for example, if a developer or a client goes bust, which is becoming more common, obviously, in today's market, ultimately the funder or the beneficiary can step into the shoes and potentially either ask you to continue to do those works or satisfy your contractual requirements, or indeed bring claims in relation to the work that's been done. So bear in mind that there may be step-in rights in that regard. In terms of what you should look out for as a subcontractor or contractor with collateral warranties, you've just got to make sure that you're not taking on any greater liability than you would have done under your agreements, and make sure you can rely upon your disclaimers and your limits of liability, if there are those, in relation to the work that you do and the designs that you produce. Finally, remember that design can be novated between parties, which means that all responsibility in relation to a design can be transferred across. And obviously, if that's the case, then all the liabilities are also transferred at that time. And that's often what is required when an employer goes from a traditional approach over to design and build. They effectively take the design and pass it across to the contractor. All I would say there is, from a contractor's perspective, is you've got to be very careful that you are aware of all the risks that are included within the obligations of the previous party, because you're taking them on lock, stock and barrel in relation to things that they may have done in the past. So you've got to verify everything. And obviously that comes at a cost, and there can be good money made out of doing that. So in conclusion then, clearly there are obligations that exist under contract. They're implied. Look out for duties that you offer and that are created by giving advice, and be careful what you say, what you advise upon. Don't be too helpful, dare I say it, not beyond the scope of your instructions or appointments. Use disclaimers, but the most important point is to get your contract right in the first place and make sure you're clear on the specification. Check every little detail. If you're taking on that design liability, remember the rule in the Hookgart case is one that must be fresh in your mind, that any standard buried in that specification, you're going to be bound by the higher one. And so you've got to be careful when signing up to provisions with detailed specifications. Thank you all very much for listening. I hope that wasn't too much information for first thing on a Wednesday morning. I'm now going to hand over to Julie and hopefully answer some of your questions.
Yeah, it was great, Ryland. Thank you. We've got a couple of questions. The first one is, if a designer only states a standard specification, such as ice, within their project specific specification, does this then lead to all clauses within the ice deemed to be included?
The short answer is it depends on specific wording in the contract. But if the contract is saying that the ICE, or whatever it may be, standard terms apply, then yes, they would be wholesale implied into the contract. In the same way, if you have a one-page order with someone that says you will be engaged on the basis of the JCT Design and Build 2016 form, even though it's not there, all of those provisions will apply.
Okay. What happens where you have a designer feeding into an architect, but they have differing views? Who takes priority? For example, we had a fire engineer confirming to us in writing that we could omit a section of cavity barrier because it was not required, but the architect advised that this was against their policy. The architect ultimately had the larger PI, so we stuck with their advice, but they are not true specialists in this field. Who trumps who?
Yeah, it's a good question. That would come back to the contractual obligations of the party making the decision. So, you know, if you're a design and build contractor and you're taking advice from those parties, then ultimately, I think the decision about PI is probably a sensible one. But you've got to make your own mind up and weigh the things up. If you've got no design liability, then really what you should be doing is asking for clarification from the contract administrator and saying, look, you know, we've got two different opinions here. Which do you want us to go with? And that would protect you. But if it's your own risk and decision making, and there are differing opinions, then I think, you know, the commercial approach in terms of the PI is a good one, because if it goes wrong, then you know, as is suggested, you then make a claim against that party for a contribution.
Okay. And then just someone's asked, could you just clarify when the 15 years of liability apply, please?
So that's a long stop. So what that means is it doesn't automatically apply. What it means is from the date of the end of the works, let's say in simple terms, you have 15 years from that point within which to bring a claim. But you can only bring a claim after the 6-year period if you only discover it after that time. So if you discover the claim or ought to have discovered it earlier, then you won't be able to won't be able to issue a claim beyond the 6 years. The only way you can bring it is if something was a latent defect. So you only discover it or the damage after the 6 years. So you're going into the extended period, and you have to bring it within 3 years of discovering it, but you cannot bring it any later than 50 years. That's why 15 years. That's why it's called a long stop.
Okay, and then someone's just added to that question. Can you contract out of the 15 years liability and state an absolute period of liability, i.e. no claim beyond 6 years of practical completion?
Yes, you can change the liability period, yes.
Okay.
Equally, you can extend it. So the opposite applies. You may say you're going to have 50-year liability. Some products, strangely, will say that they are guaranteed or warranted for 50 years or 25 years beyond the 15. So yeah, you can rely upon whatever period is agreed. The Limitation Act is really there as a default position if you haven't agreed otherwise.
Okay. Who is responsible in terms of building collapse, contractor or designers?
It depends on whether or not the contractor has taken on design liability. And it also depends upon what caused the collapse. If it was negligent design and the contractor was not responsible for design, then clearly it would be the designer. If it was negligent design and the contractor has taken on design responsibility, it could be the contractor. Equally, if it's collapsed because there's been an earthquake or a meteor shower or a fire, they're different situations again. So it depends upon the cause of the damage.
Okay. Someone else has asked, at what point do we walk away?
Well, I'm about to walk away now, Julie. I don't, at what point do we walk away? I'm not sure what they mean by that. If it's in the context of works, you can't.
I think they're talking sort of mid-construction design changes by client instruction when the options are given by the contractor. At what point do we walk away?
Yeah. Well, I mean, the key point about walking away is you must not walk away unless you've got the right to do so under the contract. If you do that, you walk away and there isn't a clear right, then you're in breach of contract and you're going to be liable for damages, which will include, the extra cost of bringing somebody else back in to complete the work. It's really not a good idea. So you must check your contractual rights before you walk away from anything.
Brilliant. Okay, well, that's the last of the questions for today, I believe. I've just had one popped up on the Q&A. Oh, here we go. Under D&B, if something is missing from the design, but later on it is discovered this is required, who is liable for costs?
If something's missing in the design...
under design and build, if something's missing from the design, but later on it is discovered that this is required, who is liable for the costs?
Well, under the standard JCT design and build, if you're the design and build contractor and there's an inadequacy, which is what it sounds to me like, there's an inadequacy in the original design, something was just missing, then you would argue that it is a change to then put it back in. And so the contractor can make a claim for the additional cost of doing that because it's been missed out of the employer's requirements. But you need to check the contract terms because, as I was saying earlier, it may be that provision that says that the inadequacies are the risk of the client may have been reversed. If it says that the inadequacies are the risk of the contractor, then I think, unfortunately, the contractor would have to pay to put it right. Okay.
And then the final one that we could be answering today, are all designers required to have runoff cover? What happens if an architectural firm closes and doesn't have runoff cover in place?
Well, there is not an obligation, generally speaking, to have any cover. So it's really a question of due diligence. It's important to check. That's why contracts will say you must have insurance cover for a minimum limit of, because if you don't do that, they won't have any cover. So yeah, that's it. It's a risk that has to be covered by the contract, and then the contract should state how long that runoff cover should last. And if it doesn't, then it will lapse. And if there's any negligence or a claim against them, they won't have any insurance. And the question will then be is, can they pay? And if they go under or disappear, then I'm afraid the risk won't be covered.
Right. Okay, well, thank you. It's been a lot to think about this morning and lots of detail there. As always, if you've got specific questions that you'd like to speak to Ryland about, please feel free to email him, rylandash@silverllp.com. Be happy to answer any questions you have. In the meantime, we look forward to seeing you at another seminar soon. Thank you, Ryland, for sharing your expertise with us. And stay safe, everyone. We'll see you again shortly. Bye-bye.
Thanks, Julie. Thanks.